Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. Today is our 23rd lecture, and we have gathered here to discuss on a very important topic. But before moving on to the topic, it is our routine practice that preamble is recited with a sense of commitment, with a sense of sentiment towards the preamble, because we strongly believe that preamble is our identity and preamble our unity, preamble our goal, and preamble our soul. So therefore I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Dear friends, before moving on to the topic, it is the usual practice of Honorable Justice Krishna Iyer. Before writing the judgment, he always keep the preamble opened on his table, and he used to see how the case law or the judgment, how it can achieve the goals embedded in the preamble of the Constitution. And one of the occasions we have discussed, when there was a dispute between the company and the directors, my Lord Honorable Justice Krishna Iyer elevated to economic justice, which is embedded in the preamble. So therefore, whenever we deal with any of the cases, ultimately the destination is achievements in the goal enshrined in the preamble. So therefore, it is our destination for which we have gathered together, and we are in pursuit of excellence. We are moving towards the destination, that is the goal enshrined in the preamble. The topic for today is, when a second SLP is maintainable, when there is no leave granted or permission granted, when there is no specific permission granted to the petitioner to come back to the Supreme Court, whether second SLP is permissible? So that is the question. When the Honorable Supreme Court says, yes, you can go back to High Court, file a review petition, exhaust your remedy, and then liberty is given to you to come back to the Supreme Court when there is a dismissal of review petition, or when you are aggrieved out of that order. When there is no such specific liberty given to the petitioner, can he come back to the Supreme Court after exhausting his remedy either under review or under filing a writ petition before the High Court? That is the question staring at us. So how are we going to answer this question? We are going to answer this question by understanding what is Article 136 and how Article 136 is being interpreted by the Honorable Supreme Court. Because the Honorable Supreme Court is the final arbiter. Under Article 141 of the Constitution of India, the judgment, the law laid down by the Honorable Supreme Court is the law and binding on all the courts within the territory of India. So therefore, dear friends, I request each one of you to travel along with me to find out the answer for the question that I posed now. For that, first and foremost, we must understand what is Article 136 of the Constitution of India. Article 136 of the Constitution of India has two clauses, Clause 1 and Clause 2. What does it say? Clause 1 say, notwithstanding anything contained in this chapter, that is chapter 4, which deals with union judiciary. Notwithstanding anything contained in this chapter, the Supreme Court may in its discretion grant leave to appeal against any judgment. See the wordings used in the Article 136. The Supreme Court may in its discretion grant leave to appeal against any judgment, decree, determination, sentence or order passed by any court. It is not the High Court alone. Passed by any court or any tribunal in any matter in the territory of India. So they have used wide terms. You may come to the Supreme Court from any order, meaning thereby it may be a final order or an interim order passed by any court. It doesn't mean it refers only to the High Court, but it also includes High Court, but also other courts, maybe district courts, maybe magistrate court might pass an order against which you can come directly to the Supreme Court under Article 136, or any tribunal. You can come directly. We were asking ourselves this question, why such a discretionary power, ample power vested with the Honorable Supreme Court? Reason is to uphold justice, to administer justice. Such a power, discretionary power vested with the Supreme Court. Can we say, is it a matter of right to the petitioner to approach the Supreme Court? The answer is no. It is not a matter of right, but it is a matter of discretion vested with the Honorable Supreme Court. Therefore, the Honorable Supreme Court may grant leave or it may not grant leave by dismissing the special leave petition in limine even without any reasons. So therefore, it is a discretionary power vested with the Honorable Supreme Court. And when they can exercise? In general cases, generally, the Honorable Supreme Court will not interfere under Article 136. Only under exceptional circumstances, they will interfere. What are those exceptional circumstances? There is a term called perversity. When the High Court order or any court which passes an order which is perversity, the Honorable Supreme Court will interfere under Article 136. Then what is perversity? Perversity means it is improper reception or rejection of vital evidence. How beautifully they have termed. The court taken into consideration the irrelevant facts and arrived at a erroneous conclusion. They failed to take into the consideration of the relevant vital documents or evidence. So that is what the perversity is. Then when there is miscarriage of justice, gross miscarriage of justice, under that circumstances, the Honorable Supreme Court will interfere under Article 136. So therefore, when the Honorable Supreme Court Justice wants to deliver justice and to punish the wrongdoer, they will interfere. Therefore, to chase injustice, sky is the limit. Their powers are not restricted in the Constitution at all, dear friends. Then who has restricted? Who has said that the Honorable Supreme Court will interfere only in the when there is a perversity? Only when there is a gross miscarriage of justice, who has imposed? It is not the constitutional framers have imposed such restrictions, but by wisdom, by knowledge, by experience, the Honorable Supreme Court itself imposed self-restrictions on its powers. Because when wide discretionary power is vested in the Honorable Supreme Court, then it should be exercised very cautiously, only in relevant cases. So therefore, dear friends, it is not a matter of right that a petitioner can claim that leave has to be granted, but it is a matter of discretion vested with the Honorable Supreme Court to grant leave or not to grant leave. Therefore, there is a common prayer in every SLP that this Honorable Court may please to grant leave against the impugned order passed by the High Court in such and such cases. It's a uniform prayer. Only when is leave granted, then SLP civil takes the birth of civil appeal. Then SLP criminal takes the birth of criminal appeal. On last occasion, we have discussed what is doctrine of merger. For example, dear friends, let me give you an example. So now we have examined what is Article 136. The question posed to ourselves is this: whether second SLP is maintainable when there is no express liberty given by the Honorable Supreme Court, for which we have seen Article 136, such a wide power. Now, we have to ask ourselves how to proceed, for which I can give you one facts of the case for better understanding. Here, SLP was filed against the High Court order, regular first appeal order, judgment. Against the judgment, the aggrieved party prefers special leave petition before the Honorable Supreme Court. But Honorable Supreme Court dismissed the matter, dismissed the SLP with the liberty given to the petitioner to approach the Honorable High Court to file a review petition. So that liberty was given. Thereafter, this SLP is dismissed as withdrawn, and he approaches the Honorable High Court and he files a review petition. After hearing the review petition before the High Court, review petition was also dismissed. Now he is aggrieved because he could not get a proper relief. Now he again files an SLP challenging two orders. One is the original order, that is RFA, regular first appeal, and then the review order. Both the orders were challenged before the Honorable Supreme Court. So now it comes up for hearing. The respondent, he says that this SLP, second SLP, is not maintainable. The Honorable Supreme Court asks why it is not maintainable. The respondent gives a reason. My lords, you have given liberty to approach the Honorable High Court under review, but you have not given him liberty to come again by way of filing SLP. So when there is no express liberty given, he cannot come. That is the law laid down by my lords. And the respondent relies upon two cases. And then judges turn to the petitioner's side. How it is maintainable? My lords, you have given two more judgments which says that after review, we can come again to the Supreme Court without even getting specific liberty from the Honorable Supreme Court. So what are those two set of conflicting decisions? One says second SLP is maintainable when there is a specific liberty given by the Supreme Court to approach by way of SLP. What are the another set of judgments which says when there is no express liberty, but still the petitioner, when he feels aggrieved, he can approach the Supreme Court. So I would like to cite this case law, dear friends. This will cover the entire issue with respect to our question. This is 2023 volume 7 Supreme Court cases. I repeat, 2023 volume 7 Supreme Court cases, page number 740. The name of the case is S. Narahari, Narahari, Narahari and others versus S.R. Kumar and others. S. Narahari and others versus S.R. Kumar and others. In this case, exactly what I have given you the facts of the case. SLP was dismissed with the liberty to approach High Court. Review was filed before the High Court. Review was also dismissed. Now the appellants, petitioners here, challenging both RFA order main judgment as well as the review judgment. Now the contention is, I am going directly to the contention, dear friends. What is the first challenge with respect to the maintainability? It is the contention of the respondents that as far as an appeal by way of SLP against an order passed in review is concerned, the provisions of Order 47, Rule 7 make it amply clear that the same is not permissible. That is to say, no appeal by way of special leave petition against an order passed in review is maintainable. That is their first contention. That when there is a specific prohibition under Order 47, Rule 7 of CPC, that SLP is not maintainable against the dismissal of review. Second challenge is, this is very important. It has also been contended by the respondents who is challenging the maintainability of SLP. It has also been contended by the respondents that this court, while dismissing the original special leave petition filed by the petitioners, therein, while it granted liberty to the petitioners to approach the High Court in review, but did not give the petitioners specific permission to file a subsequent special leave petition before this court. Such lack of explicit permission, as per the respondents, places a bar on the petitioners to approach this court again. For this, the respondent has relied on Sandhya Educational Society versus Union of India. So, the respondent questioning the maintainability of special leave petition, that there is no expression by the Honorable Supreme Court for granting liberty. Therefore, where is the question of maintaining second SLP? Now, the Honorable judges framing their issues, what is to be determined in this case? The limited question, therefore, posed before us for consideration is whether liberty granted by this court to approach the High Court in review automatically places the said matter in the escalation matrix and makes the remedy of special leave petition available again. So they are posing the question to themselves for consideration. When we are granting, when the Honorable Supreme Court granting liberty only to file review, whether does it mean that, whether it includes that liberty to come to the Supreme Court when there is no express mentioning of such liberty in the order. So for this, they are relying upon two judgments, which says that it requires express mentioning of the liberty. In Vinod Kapoor versus State of Goa, Vinod Kapoor versus State of Goa, the petitioner therein had filed a writ in the High Court there, and the same was dismissed. So writ petition was dismissed. As against this, petitioner therein filed a review in the High Court and also filed special leave petition in Supreme Court. So writ petition was dismissed. He files a review before the High Court also, as well as he prefers special leave petition before the Supreme Court also simultaneously. When the special leave petition came to be heard, the petitioner therein stated that he had already filed a review and hence sought liberty to withdraw the SLP, and on the same grounds the SLP was dismissed as withdrawn, that he will be pursuing his review before the High Court. After the withdrawal of the special leave petition, the review petition was heard by the High Court. However, the same was dismissed. Aggrieved by the said dismissal of the review, the petitioner therein filed another special leave petition in the Supreme Court, second SLP. While dealing with the similar fact circumstance as in the present case, wherein a consecutive special leave petition was filed and the order in the original special leave petition only gave an explicit liberty to approach the High Court, this court held that subsequent special leave petition was not maintainable. So in Vinod Kapoor's case, they are saying second special leave petition is not maintainable, and the relevant paragraph is reproduced here, dear friends. Para 12 of Vinod Kapoor's case, there is nothing in the decision cited by the appellant to show that this court has taken a different from the view taken in Abhishek Malviya versus Additional Welfare Commissioner with regard to the maintainability of an appeal by way of special leave under Article 136 against an order of the High Court after an earlier special leave petition against the same order had been withdrawn without any liberty to file a fresh special leave petition. Similarly, there is nothing in the decision cited by the appellant to show that this court has taken a view that against the order of the High Court rejecting an application for review, an appeal by way of special leave under Article 136 of the Constitution is maintainable. In the result, we hold that the civil appeals are not maintainable, and accordingly we dismiss the same. In support of this contention, they are again referring to one more judgment, Sandhya Education Society. So two judgments are relied upon by the respondents questioning the maintainability of special leave petition. So in Sandhya Education Society, a two bench of this court, while accepting the principle laid down in Vinod Kapoor's judgment, categorically held that once special leave petition is dismissed as withdrawn, if no explicit liberty has been granted to approach the Supreme Court by way of a subsequent special leave petition, the same cannot be allowed. So both Vinod Kapoor as well as Sandhya Education Society, they have laid down a law, the Honorable Supreme Court has laid down a law by saying the second SLP is maintainable only when we grant specific liberty, express liberty, that you exhaust your remedy by filing a review. If you are aggrieved still, you can come back to us. When such liberty is given, only then second SLP is maintainable, otherwise no. This was the submissions made by the respondent questioning the maintainability of special leave petition. But what about the petitioners? They said it is maintainable, for which they have referred to two cases, dear friends. Per contra, the learned counsel appearing on behalf of the appellants has relied upon Code Distilleries Limited versus Sri Mahadeshwara case, wherein it has been observed that the doctrine of merger is not applicable in cases where the dismissal of special leave petition is by way of a non-speaking order. The relevant paragraph of the said judgment for the sake of convenience are reproduced herein. So the petitioners wants to canvass before the Honorable Supreme Court that second SLP is maintainable, and that cannot be questioned at all because of Code Distilleries. Why they are relying upon Code Distilleries, dear friends? The reason is, in Code Distillery they have said, and on the last occasion also we have discussed in detail, when SLP is dismissed in limine, meaning thereby at the threshold, even at the admission stage itself, what is the legal effect of dismissal of SLP in limine? That is the question. Does it, whether such dismissal meaning thereby does it give certificate to the correctness of the judgment passed by the High Court or any other court? The answer is no. Dismissal of special leave petition in limine means that the Honorable Supreme Court, they do not wish to exercise their discretionary power in respect to that case. That's all. It is not a fit case to exercise our power, that is under Article 136. That is what the meaning is. Therefore, it does not say that mere dismissal will not bar the petitioner from filing a review petition or from filing a writ petition under Article 226 also. That is also maintainable. We can say, the other side might say before the High Court, my lords, SLP was dismissed. Final authority has dismissed their matter. How come they can file a review? How come they can file a writ petition under Article 226? So dismissal of SLP should act as a bar, should be a bar on the petitioner from instituting any writ petition or review after the dismissal of SLP. But the answer is, even after dismissal of SLP in limine, the petitioner, if he is aggrieved, he can go to the High Court. There is no bar. He can go to the High Court to file a review petition or writ petition. He can exhaust any other remedies that are available. Therefore, it is not a closure of the remedy. The Supreme Court dismissal of SLP, it is not closing any of the rights that is vested with the petitioner. It only says that this is not a fit case to exercise our discretionary power. That's all. So, what is the effect? That High Court order does not merge with the Supreme Court order. Therefore, doctrine of merger does not apply at all. So, legal effect of dismissal of special leave petition in limine means no doctrine of merger. I would like to refer Code Distillery in para 20. Please note down, dear friends, they have beautifully explained. Kunne Ahmad case they have given in detail. But what is the essence? Tell us in bullet points. It is available in Code Distilleries Limited, 2019, Volume 4, SEC, page number 376. I repeat, dear friends, 2019, Volume 4, Supreme Court Cases, page number 376. The first bullet point, this is I have extracted from para number 20 of the judgment. Bullet point number 1. Dismissal at the stage of special leave petition. Dismissal at the stage of special leave petition, hyphen, without reasons, no question of res judicata or no question of merger. They have put it very simply, dear friends. No res judicata, no merger when SLP is dismissed at the stage of special leave petition without any reasons. This is first bullet point. The second point is, dear friends, in Kunne Ahmad case, running to several pages, but those, whatever the essence that they have extracted in these points. Bullet point number 2. Dismissal of SLP by speaking or reasoned order. So it's a speaking order. Still they dismiss it by way of a speaking order. Then what is the effect of it? There is no merger. Still no merger. High Court order remains itself. It does not get merged with the Supreme Court order. No merger. But in a speaking order, dear friends, there is a thin line. Distinction is there. In a speaking order, the Honorable Supreme Court may refer to some leading cases also. So, what is the finding when they discuss about the law? Though they dismiss the SLP, but by way of a speaking order, by citing some landmark judgments, that will have a binding effect. Under Article 141 of the Constitution of India, any legal discussion, even in the dismissal of SLP in limine, that has a binding precedent under Article 141. So it is a binding effect. So dismissal of SLP by speaking or reasoned order, no merger but rule of discipline and Article 141 attracted. So any discussion with respect to landmark judgments in SLP that has a binding effect. Rule of discipline. What is rule of judicial discipline? In the judicial hierarchy, we know district judiciary, then High Court, thereafter Supreme Court. When Supreme Court delivers a judgment, it is a law binding on all the courts in India. They are bound by it and they are abide by it, and they should follow whatever the law laid down by the Supreme Court. That is what the discipline is. Judicial discipline, respecting the higher authority, respecting Supreme Court because it's a final arbiter. So number 2 bullet point is over. Number 3, the third point. Leave granted. Now the Honorable Supreme Court, there is one more possibility, leave granted. After granting leave, it was dismissed without reasons. So now SLP Civil has taken the birth of civil appeal, but still it is dismissed without reasons. Merger applies, doctrine of merger applies. So what is the possibility after granting leave? There may be a dismissal, there may be a modification to the High Court order, affirmation, modification or reversal, setting aside. Whatever it is, the High Court order gets merged with the Supreme Court order, meaning thereby High Court order loses its identity. Sink means appear, merge. It disappears. High Court order disappears, it merged with the Supreme Court order. That is what the doctrine of merger is. To put it very, very simply, as a layman, now we have talked about as a lawman, as a layman, tell us what is doctrine of merger. In this winter, we generally take tea or coffee. We just put water in the vessel and we get it boiled. And then we add milk to it. So where is the identity of water? Water, we have seen it. Now adding milk to it, the identity of water merges with the milk. So now we are able to see only the milk. So water like the High Court order and milk is like a Supreme Court order. So once leave granted, the High Court order merges with the Supreme Court. So High Court order disappears. It merges with the Supreme Court order. This is what the merger is. One more example. When trial court passes an order in favor of a landlord, saying that tenant should be evicted because he has not paid the rent for several months. So it was in favor of the landlord. Trial court has granted him favor. Now who is aggrieved? Tenant is aggrieved. Tenant goes to the High Court. Tenant has got a favorable order there. Now landlord is aggrieved. He comes to us. Sir, I won my case in trial court, but High Court reversed it. Which order will prevail? Whether trial court order will prevail or the High Court order will prevail, because trial court order is in my favor, but High Court order is in favor of my tenant. So which order will prevail? Then we will say, landlord, my lord has said that High Court order always prevail. Reason is trial court order is set aside. The trial court order is merged with the High Court order. So therefore, trial court order lost its identity, lost its significance. So superior authority order will always prevail over the authority below. So this is what the doctrine of merger is. So hope we have understood what is the effect of dismissal of SLP in limine with reasons, without reasons, and after granting leave, doctrine of merger applies. But so in this case, by referring to Kunne Ahmed case and Kode Distillery, they said we always have a liberty to come to the Supreme Court when there is no specific liberty being granted. So therefore, second SLP is maintainable. This was the contention made by the petitioners before the Honorable Supreme Court. But what did this honorable bench has held in this case is, you are citing two different conflicting decisions. Though in Coded Distillery, they have not discussed specifically about maintainability of second SLP, but the logic by saying that dismissal of SLP is only that it is not a fit case, therefore they can approach. So logic is applied here. Two different findings, therefore matter is referred to a larger bench. So here, what the Honorable Supreme Court has held is, therefore, in light of the above mentioned observations, we are of the opinion that to put a quietus to such an issue, it is necessary for the same to be adjudicated and deliberated upon by a larger bench of this court. Further, since only after such a preliminary objection is decided, can the merits of the present case can be entered into, the same is to be placed before an appropriate bench after the question of law is decided by the larger bench. Accordingly, let the papers of the case placed before the Honorable Chief Justice of India for constituting a larger bench. So after seeing this, our team of interns, they have made a research what is the subsequent development. According to our best of our ability, we could find that till now larger bench was not constituted and it is still pending for consideration. So with this, dear friends, let me sum up, and I have taken you to Article 136, such a wide power, and then we have discussed about Vinod Kapoor case, Sandhya Education Society on one side, relayed by the respondents questioning the maintainability, that the second SLP is maintainable only when there is an express liberty granted by the High Court. But on the other side, the petitioner said second SLP is maintainable even when there is no express liberty given by the Supreme Court, for which they have relied upon Coded Distilleries and Kunne Ahmed case. Now two set of conflicting decisions. This is also judicial discipline, dear friends. Two judges bench cannot decide over the correctness of three judges bench. So the matter has to be placed before an Honorable Chief Justice of India to constitute a larger bench to settle the law, to lay down a law for the rest of the country. Therefore, the Honorable High Court can easily follow the proposition settled principle of law by the Honorable Supreme Court. So with this, we have made a sincere endeavor to answer this question, dear friends. Thank you so much for your patience hearing.